order. This is the ruling that came out of yesterday's hearing. Starts with their objection. They started many of their responses, the government, to the discovery responses, discovery being the process prior to trial or hearing in which the parties exchange information through depositions, question and answers under oath, written questions under oath, which are called interrogatories, or requests for production of documents, which is what it sounds like. So the way the Trump administration started off all of their objections with this false premise. It's the false premise about what the Supreme Court ruling actually says, and therefore we can't answer the discovery. Here's how the judge handled that on page 1. Defendants object to certain discovery because they claim the requests are based on, quote, the false premise that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. Defendants and their counsel well know that the falsehood lies not in any supposed premise, but in their continued mischaracterization of the Supreme Court's order. See what the judge did there? She said there's only one falsehood here, and the falsehood is what the position of the Trump administration. That order made clear that this court properly required the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that the case is handled as it would have been had he not been improperly sent to El Salvador, or what she says, lawlessly, illegally sent to El Salvador. She then goes on, she says, defendant's objection reflects a willful and bad faith refusal to comply with discovery obligations. And all of their objections on that ground are overruled. Then they try to assert privilege. Oh, we can't answer that question, Judge. State secret privilege, executive privilege, attorney-client privilege. But in order to do that properly in federal court, and these lawyers know better, you have to set out the facts that support the privilege, and you have to create what's called a privilege log, which is a listing of all the documents by description and sufficient enough so that you can debate it without having the other side see the document. You have to prepare a privilege log. They didn't prepare a privilege log. They didn't even provide any facts to support any of their privileges. And here's what she said about that on page 2. Equally specious, defendants' objections on the grounds of privilege are rejected. They provide no supporting information or analysis. As defendants and their counsel know, the proponent of a privilege must demonstrate the legal and factual basis to invoke the protections that such privilege affords. Of course, they don't do that. Instead, on page 3, she said, defendants and counsel. See, she's putting counsel, the lawyers, on notice that she could also separately discipline them. Defendants and counsel stubbornly refuse to provide any basis for the privilege, she says. It is a willful refusal to comply with the court's discovery orders, and she finds that an offer to now, late in the game, prepare or consult about a privilege log is too little, too late. And so she's has ruled, here's what she says on that. Defendants have known at least since last week that this court requires specific legal and factual showings to support any claim of privilege. Yet they have continued to rely on boilerplate assertions. That ends now, 6 p.m. Eastern time today. They are to turn over all the documents. No more privilege assertion. She's effectively gotten rid of those. But she's going to give them one more chance to supplement and provide the required facts and privilege log by 6 o'clock today. Or that's it. She struck all of that. On page 4, she says defendant's objection about the timeline for the documents is rejected. Defendant, she says, arbitrarily cramped reading of the court's order is rejected. At a minimum, the discovery period contemplates the time immediately preceding Abrego Garcia's lawless seizure on March 12, 2025, and his transport and confinement to CCOT. She then takes on their objections about information about Abrego Garcia's removal to El Salvador, his initial placement in CCOT, that's the prison, or his continued confinement there. The objections are overruled. Information regarding Abrego Garcia's removal, as well as placement and confinement, cut to the heart of the inquiry. She wants to know what steps, if any, defendants have taken or will take to facilitate his release from custody. Then she doesn't believe them about that there's only 2 people that are involved with the removal to El Salvador of Abrego Garcia and his initial placement in CCOT, listing Robert Cerna and Evan Katz She said, given the context of this case, defendants have failed to respond in good faith, and their refusal to do so could only be viewed as willful and intentional noncompliance. Now, let me take a break here for a minute. When a judge uses this language, bad faith, willful, violation of the law, not in good faith, evasive of fundamental discovery obligations, she is winding up, and the pitch is going to be contempt and findings of bad faith and sanctions, not just against the Trump administration. Look out, Mr. Ensign, for the Department of Justice, because you're right in the line of fire here for the judge. Now, she's given them to supplement, fix, or provide the documents 6 o'clock today. I'd bet dollars to donuts they don't do it right. How about you guys? Leave a message here in the notes here, in the comments, which means the lawyers will then come back to the court for another hearing. And I think at that point, she will either find them in default, the government, order more discovery, and or move to that contempt hearing that we talked about. I'm going to talk about it in another hot take coming up next about a concession after the Fourth Circuit Court of Appeals ruled in Judge Zinnis's favor, in Abrego Garcia's favor, just last week with Judge Wilkinson. It has moved the rock and has changed the approach for the Trump administration in trying to get Abrego Garcia back. I'm going to do that in another hot take to follow this one. So until my next reporting, look, you're already here on Midas Touch. Take a minute, hit the subscribe button. We have a channel that runs parallel to Midas Touch on all things law and politics. It's called Legal AF. What else? Come on over there as well. Hit that subscribe button. We're in a drive for subscribers right now. We've been doing about 60, 70,000 new subs every month, and we're trying to get to 1 million before our 1-year anniversary. And with your help, we're certainly going to do it. And that allows me, as the curator of that channel, Michael Popak, I'm allowed to go out and get some other great contributors. I'm talking to 2 amazing ones. They're going to be joining us starting next week. You're going to be blown away with who's joining Legal AF. But in order to find out, you got to subscribe, which will also give you reminders for all of our videos. So until my next reporting and my next Legal AF podcast or on the channel, I'm Michael Popak. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.